Hello, everyone, and thank you for joining us. My name is Tamara Kharroub. I'm the Deputy Executive Director and Senior Fellow at Arab Center, Washington, D.C., and I'm pleased to be chairing the discussion for today. I'm glad to welcome you all to this panel titled NGO Actions in Western National Jurisdictions. This is the second session as part of a conference series organized by the Arab Center for Research and Policy Studies in Paris, or Kharroub Paris. The four-part conference deals with the role of law in the Palestinian struggle for national liberation. Today's session specifically focuses on the repression of Palestine advocacy work in three different contexts: the United States, Canada. I got some notification about language. So we're focusing on three different contexts today: the United States, Canada, and Europe, looking at repressive practices against Palestine activism, as well as the potential legal avenues to support Palestinian rights and activism in those contexts. As you all know, the last 48 hours have seen significant developments in the region, with Iran's unprecedented attack on Israel in retaliation for Israeli strikes on its diplomatic office in Syria. And there are still growing fears of a wider regional war. This has clearly distracted the news cycle away from the genocide in Gaza. While the media has moved on, it seems, Israel's war on Gaza continues, and so does the repression of any opposition to it. And we continue to see the persistent dehumanization and anti-Palestinian racism that perpetuate this repression. While the silencing and suppression of Palestinian rights activism is not new in the West, it has significantly intensified over the last 6 months of Israel's war on Gaza. Since October 7, more than 34,000 Palestinians have been killed in Gaza, including 13,800 children and 8,400 women. More than 76,000 have been injured. More than 8,000 are still missing. Thousands are being tortured, and 2.3 million are displaced and are being starved as we speak. Meanwhile, brutal violence and land seizures continue in the West Bank. Yet, those calling for a ceasefire, the delivery of humanitarian aid, and the end to Israeli occupation and apartheid are being attacked and silenced in the West. Just a few days ago, prominent Palestinian British medical doctor who was in Gaza for the first 45 days of the war, Dr. Ghassan Abu Sitta, was barred from entering Germany to participate in a conference, and was even warned not to participate remotely or send a video message. Otherwise, he will face legal repercussions, such as fines and jail time. Over the last 6 months, we've seen increased efforts, especially across North America and Europe, to repress, silence, intimidate, threaten, and criminalize Palestine solidarity advocates, whether in the workplace, on college campuses, or in public spaces. In the US, even 2 Ivy League university presidents were forced to resign for not repressing Palestinian activism enough. As such, this session today will focus on exploring the legal implications of Israel's war on Gaza, the weaponization of laws and other means to repress Palestinian rights activism, and the legal tools and opportunities available for Palestine solidarity work around the world. To address these issues, we do have an excellent panel of experts with us that we are thankful for their time and contributions. I will briefly introduce them in the order in which they will speak. First, we have Maria LaHood. She is the Deputy Legal Director at the Center for Constitutional Rights, a New York-based nonprofit that works with communities under threat to fight for justice and liberation through litigation, advocacy, and strategic communications. She joined the center in 2003, where she has sought accountability for international law violations, defended Palestinian rights advocates under attack in the United States. Second, we have Faisal Bhabha. He is an associate professor at Osgoode Hall Law School in Toronto, Canada, where he also serves as the faculty director of professional LLM in constitutional law. He teaches, researches, and publishes in the areas of law, human rights, and legal ethics. In conjunction with his academic research and teaching, he maintains a small law practice, advising and representing a variety of individuals and public interest organizations in matters pertaining to constitutional law and human rights. And third, we have Layla Kattermann. She is the Monitor Project Manager at the European Legal Support Center, which is monitoring racist attacks, exposing the unlawful targeting of Palestine advocates, and is a growing legal network to defend the Palestine solidarity movement in Europe. She studied international studies at Leiden University, focusing on the politics of law, the media discourse on Palestine, and Israeli disinformation. Thanks to all of you for taking the time to contribute to this important discussion. In terms of format, I would like to do 2 rounds of interventions. The first focusing on the repression of Palestine advocacy work, and the second discussing the legal opportunities for government accountability. I will give the speakers today about 10 to 15 minutes each in each round. Then we will take questions from the online audience. And here I would like to remind the audience that you can send in your questions at any time during the discussion using the Q&A feature on Zoom. Please identify yourself and indicate to whom your question is addressed. Please keep it brief and in question format so we can take as many questions as possible. And now, without further ado, let's start the discussion. In the first round, I would like to ask each of the speakers. First, welcome, Maria, Layla, Faisal, thank you for joining us. In the first round, I would like to ask each of you to discuss the repression of Palestinian rights activism and speech in your context, whether it's the United States, Canada, or Europe. In what ways Palestine solidarity work and advocates have been silenced and repressed, and what legal measures have you taken or can be taken to challenge these actions? I would like to start with Maria, who will focus on the United States. Maria, so what is the nature and landscape of this repression in the United States? Who is behind it? What methods are being used to legitimize it? And what measures are being taken to counter and challenge these practices? Maria, go ahead.
Thank you. Thanks so much for having me and for hosting this important panel. It's really good to be with people from all over the world who are part of the struggle in these horrific times. Just to say a little bit about CCR, we were founded in the 1960s by lawyers representing civil rights activists in the South, and we've grown to support movements for social change and liberation around the US and around the world. I'm also on the board of Palestine Legal, which protects the civil and constitutional rights of people in the US who speak for Palestinian freedom. Over the last 20 plus years, CCR has advocated for Palestinian rights in US courts. And in the last, I would say 13 years, we've advocated on behalf of people in the US who have been retaliated against or sued or fired or disciplined for advocating for justice for Palestinians. And as the movement has grown in the US, so has the suppression against it. The movement is growing daily in the US. People are speaking out despite the unprecedented attacks. People are in the streets, shutting down bridges, going wherever Biden goes, passing ceasefire resolutions and boycotts, protesting on their campuses, protesting in their votes, tax resistance, whatever they can do to resist. And in response, the incidents of suppression have increased exponentially in the last 6 months. There have been thousands of incidents. At work, people are being silenced and disciplined. More than 160 people have been fired from their jobs for speaking out, and that's what we know of. Some are just leaving. On college campuses, students are being disciplined, doxxed, suspended, expelled. Groups are being banned. People are being arrested for protesting. They're being silenced, often, by being falsely labeled anti-Semitic for criticizing Israel or supporting terrorism for supporting Palestinians. So there's been a lot of pressure on universities to crack down on student protest, from donors from Title VI civil rights administrative complaints, from lawsuits, from the Congressional House Education and Workforce Committee that you mentioned that helped bring down the presidents of Harvard and the University of Pennsylvania. And Columbia is going to be before them on Wednesday. And these are the same, I mean, these are just some of the pressure points. And some of these lawmakers are the same ones that are trying to end diversity, equity, inclusion programs. So they're the same ones who are, fighting a conservative fight to end anything that they see as progressive, but that are taking on this fight, claiming that advocacy for Palestinian rights is anti-Semitic. So it's not new what we're seeing, but the scale is unprecedented. It's like every tactic that has been tried is now being used everywhere at the same time. I'll focus mostly on the litigation that's happening and just give a little bit of background. I think if people know, Israel's been building the infrastructure for these suppression efforts for years. I mean, it was involved in efforts to suppress BDS in the US in a case we had as early as 2011. And then in 2017, Israel set aside $72 million to fight against what they call the delegitimization of Israel and set out its plans to establish and fund an international legal network to stop the global movement for Palestinian freedom. So it's contracted with the International Legal Forum, for example, an Israel-based NGO and global network of groups fighting BDS in 40 countries around the world, and administers grants to their network members. So there are various organizations and lawyers in the US who have been bringing cases to suppress criticism of Israel. So going back to 2011, CCR represented the Olympia Food Co-op board members who were sued for passing a boycott of Israeli goods. And this was a case that the Israeli Minister of Foreign Affairs and Stand With Us, one of these suppression groups, was behind. And this is a local food co-op that decided not to carry items from Israel. And it took 9 years to get the case dismissed once and for all. CCR is still defending against a similar case brought by the Brandeis Center and now by the Deborah Project against the American Studies Association and several individuals, including Stephen Salaita, who we represent, in response to a resolution that the ASA passed in 2013, endorsing the call to boycott Israeli academic institutions. That was 11 years ago, and litigation's still ongoing. The federal case was dismissed after 3 years because damages weren't sufficient to be in federal court. Then they sued in DC Superior Court. We brought what's called an anti-SLAPP motion. I don't know if there's something comparable in other countries, but in the United States, about 31 of the states and DC have what are called anti-SLAPP laws. SLAPP is a strategic lawsuit against public participation. And essentially, they are passed to deter the abusive use of courts to chill free speech. They're supposed to make it quicker to dismiss meritless claims that target protected speech and generally require the plaintiffs to pay attorney's fees if the plaintiffs lose under one of these motions. So we brought anti-SLAPP motions because it was in some jurisdictions, you can bring them in federal court, but in DC, you can only bring them in state court. The court denied our motions. We appealed. We won. We went back to the Superior Court. We won and moved for attorney's fees, which would be a great deterrent to these meritless cases. And plaintiffs have appealed. So we have argument actually May 8th in the DC Court of Appeals, which is the highest court in DC. We recently won, and I'm trying to give these cases because to show you how they last so long and they are, intended to chill. We had another case that the JNF, the Jewish National Fund, and individuals brought against the US Campaign for Palestinian Rights, and this was under the Anti-Terrorism Act. The International Legal Forum claimed credit for bringing this case. So the JNF alleged that US Campaign for Palestinian Rights was liable for damage to land caused by incendiary kites and balloons launched from Gaza during the Great Return March, because US Campaign had expressed support for Palestinian rights to protest and demand the right to return without being shot at by Israel. And because US Campaign had served for a time as the US fiscal sponsor for the Boycott National Committee. And one of the Boycott National Committee members is another coalition made up of all Palestinian parties, one of which is Hamas. So it was clearly a meritless case, and the court dismissed it as meritless. And, it was appealed and we won. And then they asked the Supreme Court to hear it, which we didn't even bother to respond to because you don't have to. But after October 7th, plaintiffs submitted a letter to the Supreme Court saying, Hamas, October 7th. And then the Supreme Court asked us to respond. So we did. Thankfully, in January, the Supreme Court refused to hear the case. But now the ILF and the National Jewish Advocacy Center have brought a case against UNRWA USA, also under the Anti-Terrorism Act, because of its support for UNRWA, the UN agency. And we all know what's happening with that. Some of those same plaintiffs sued the Associated Press under the ATA, claiming that the AP paid a photojournalist for images of Israeli hostages being taken into Gaza. Other plaintiffs, represented by Sharat Hadin lawyers, sued the Secretary of State and the State Department, trying to force them to permanently stop funding UNRWA because they've only implemented a temporary pause in that funding. And there are also several cases against universities claiming discrimination and a hostile environment for Jewish students. So again, the Brandeis Center sued the University of California, focused on the law school. I mean, essentially, these cases rely on the argument that anti-Zionism is anti-Semitism. And here, in that case, as a preliminary matter, the judge said, no, it doesn't. But that case is still ongoing. There's also cases against private universities, Columbia and NYU. Title VI of our Civil Rights Act of 1964 prohibits discrimination based on race, color, or national origin by any program receiving federal funding. So it's not just public schools who can be sued, it's also private schools. And since 2004, there have been efforts to have that definition cover anti-Semitism and to have the anti-Semitism definition include essentially Palestinian rights advocacy, including trying to get the Department of Education Office of Civil Rights to codify the IRA definition of anti-Semitism, which we've been pushing back against. So the number of just Title VI complaints that are on the administrative level claiming hostile environments for Jewish students have ballooned. But there are also now, students using Title VI to bring claims for anti-Palestinian hostile environments at universities. So we have both of those things going on. And then we have also affirmative lawsuits fighting back against the suppression. So in response to Columbia banning SJP and Students for Justice in Palestine and Jewish Voice for Peace groups, Palestine Legal and NYCLU brought a case under New York law. We had brought a similar case against Fordham. The New York law allows you to challenge decisions by private institutions that are arbitrary or go against their own guidelines. So even though they're not subject to the First Amendment, they have to comply with their own procedures and policies. So there's that case. There was also, sorry about the background noise. ACLU and Palestine Legal also sued over the Florida SJP ban. The Anti-Defamation League had called on university presidents to investigate SJP chapters claiming material support for terrorism. And the Florida governor, Ron DeSantis, used the same rationale to order a ban of SJPs from state public universities. So although that case, the judge dismissed the case because he found it likely that the university found it unlikely the university would actually follow through with the SJP ban order. It was recognized it would likely violate the First Amendment to do that. There's also, I think people have heard about Accuracy in Media, who's been sending around these mobile billboard trucks displaying students' photographs and their names under the headline, for example, at Columbia's leading anti-Semites. And they've been driving around the campuses, around students' neighborhoods. So there's a case brought by a law firm, Beldock, Hoffman, and Levine against Accuracy in Media, suing them for defamation, for privacy violations, and for other claims. So all these cases are, at a pretty preliminary stage, but people are fighting back. These attacks on activists all share the same objective: to eliminate support for Palestinians in an effort to isolate and eliminate them, to distract from the real human rights violations from the genocide, and to win the narrative war. And so, rather than just stopping what it's doing, Israel and its apologists are trying to stop people from criticizing it or from supporting Palestinians because they have no defense. So the tactic is to try to stop the debate. And that's how suppression works, by creating a climate of fear. So, the biggest problem with all of this is the chill and the widespread impact that goes beyond the individuals targeted. So the most important thing for people to do is not to be distracted, chilled, or silenced, and to use these attacks as opportunities to further discuss the real issues and to change the narrative. It's not just the free speech principles, but also the underlying human rights issues about Palestinian freedom and the genocide and U.S. complicity for us here in the United States. So I'll stop there.
Thank you so much, Maria, for this comprehensive presentation and the alarming nature of the increase in repressive tactics. And it's alarming that litigation, as you said, takes a long time, and it's even if it's meritless, but it is the climate of fear that is the most effective and concerning in this case. Next, I'd like to move to Faisal and the focus on the Canadian context. Same questions for you, Faisal.
Good afternoon, everybody. Thanks for including me in this discussion. It's just been interesting to hear the perspective from the U.S. because so much about what we've been contending with in Canada is very similar. There's a couple of distinguishing features maybe that I'll start with that make Canada different from the U.S. And I'm starting with that because I'm saying what we have experienced is very similar, though on a smaller scale, to what's happening in the United States. And we look to the United States actually for the canaries in the coal mine for the indications of where things are going. Okay. So, well, one thing is that Canada is a much smaller context, and that operates for the better and for the worse. Smaller means that we can have, in some ways, more direct influence, but it also means that leaders, institutional leaders, and political leaders are much more often, personally influenceable, and so I guess it works both ways, in that there's a real competition for access to political leaders right now, and there's a lot of lobbying happening. And although there's a huge imbalance in the resources at the level of political influence, I think in Canada there has been some degree of breakthrough just because it is a smaller provincial, more kind of provincial political context in which it's easier for smaller interest groups to make some headway. And one thing that has happened since October 2023 is that constituents in the democratic society that previously were not putting money and energy into the issue of Palestinian justice, but maybe who always cared about it, are now putting their money where their mouth is. And so there has been, we at the Legal Center for Palestine, which I want to talk a little bit about, have noticed this in terms of our attempts to fundraise. And so the Legal Center for Palestine was modeled very much along the lines of Palestine Legal in the United States. We received, in fact, material support. To the best of my knowledge, I was not involved in those discussions, but I know that we couldn't have built the institution that we have without that kind of support and solidarity, and we're very appreciative of that. And I think it's an important model to highlight for others in other parts of the world. And conversations like this, I think, are helpful to promote that. We had volunteers basically building the organization from the inside for about a year before October the 7th, 2023. And we had taken on some small projects here and there, responding to members of the Palestinian Canadian community, responding to individuals, people who had been wrongfully dismissed from their jobs, people who were facing social media backlash, students who are facing unfair conduct investigations. The same kind of stuff that Maria's been talking about has been happening here. I think 2010 is a pivotal year. That was a year that Haaretz newspaper, the Israeli press, reported that the government was investing in Hasbara in a serious way. I think it probably pre-existed 2010, but in 2010 there was a major shift. Benjamin Netanyahu, I believe, came to power either late 2009, 2010, and explicitly committed to the propaganda war. And it's around that time, 2011, I believe, that experts put the social media revolution, date the social media revolution to that point. It's around that time that people started consuming information and, importantly, news predominantly from devices rather than from print media or even websites. And so I think this confluence of things have really created the conditions that made a Palestine Legal so important, and that created the impetus for the Legal Center for Palestine. We are not as well developed in our activism. We do not have as many cases. But what had been happening is there had been an informal network of Canadian lawyers doing these kinds of cases, doing defamation lawsuits against B'nai B'rith, which is a sort of equivalent of the ADL in the US, probably even more vociferous in their pro-Israel advocacy and vicious in their attacks on pro-Palestinian voices. And so there have been a few cases of people fighting back, and these are people who are involved with the LCP. So these were not LCP cases, but the LCP was kind of making itself on its own. I was representing a couple of people. One case that I'm happy to talk about as an example involved an individual who was fired from his job at a university where he was a part-time TA. He was a doctoral student. He was also a part-time imam at a local mosque. And in 2017, a pro-Israel kind of fake news website published a inaccurate translation of a supplication that this part-time imam had delivered some 8 months earlier. But this was timed to coincide with what had then been the worst attack on Muslim Canadians in the history of Canada, which was the murder of 6 praying Muslims at a mosque in Quebec City in January of 2017. And literally 3 or 4 days after that event, this kind of stream of fake news promoting Islamophobic tropes began to emerge. And one of them pertained to this client of mine who was this part-time imam at this downtown Toronto mosque. And what happened is these falsely attributed words that he had allegedly said in his prayer were then used against him by his employer, the university, to fire him from his job because Jewish students had apparently complained, and the Jewish community had apparently been mobilized to complain that Jewish students could not be safe in a classroom with an individual who had prayed he was alleged to have prayed basically for the murder of Jews and had called them filth. When in fact he had been praying about the desecration of holy sites in Jerusalem during Ramadan of that year, which has happened every year in Jerusalem. And so you see the way that the ability even for religious leaders to pray for Palestine during Ramadan. This was actually on the prayer in question had been delivered on the holiest night of Ramadan that year, and the mosque had shared it online for its congregants. But there are these Hasbara actors out there that are scouring all material that they can obtain and weaponizing it against members of vulnerable communities. The second distinguishing thing about Canada, I guess, just to finish that point, is that we're smaller than the U.S. We also are known for being a nicer culture, a nicer people, at least people who perform niceness, and that actually works against us in terms of pro-Palestinian advocacy, because we're a nicer country. We're a country that cares more about anti-discrimination. Certainly, we adopted anti-discrimination legal standards from the United States, no doubt. But we've taken it much further. We have constitutional protection for affirmative action, so that question doesn't have to keep getting recycled through the Supreme Court. We accept that affirmative action is part of our commitment to equality. But the problem is that when members of a vulnerable or historically disadvantaged group complain about feeling scared, we tend to put a lot of weight in that subjective assertion. And it becomes very difficult to challenge assertions by members of minority groups that they feel unsafe or scared. And this is the challenge, is that anti-Semitism is weaponized through the subjective feelings of some Jewish students on campuses, of some Jewish people in workplaces, such that it puts a chill on the ability of Palestinians and their allies to express themselves in the most modest ways, to wear a keffiyeh, to express a freedom chant. These things have become so controversial, and what we've noticed is that members of the Palestinian identified community and their allies tend to be either from the global south or descended from people of the global south, and who may and who take liberal rights seriously, who take the commitments of Western society, the grand proclamations, the self-righteous self-valuing of the West as best, seriously, and they exercise those liberal rights, and then they get them thrown back in their face, and they get told, well, it's not for you, or it's subject to these conditions, and they're expected to abide by the sensitivities of the dominant classes, of the dominant communities. And this has become very apparent post October 2023. The extent to which liberal rights are unequally enjoyed. And so then the question is, well, what does anti-discrimination law offer to correct that? I guess one thing to say is that we do not yet have an adjudicated decision, that is from a court or from any kind of tribunal that is empowered to adjudicate questions of discrimination, that equates anti-Zionism with anti-Semitism. There have been attempts to do that, and there are ongoing attempts to do that. There's also attempts to push the IRA definition of anti-Semitism into statute, which has not yet been achieved. So it's not yet law, but it's as close to it as possible. Political leaders have rushed to commit themselves to the IRA definition, even as the law resists. And we're going to continue to see that pressure between political actors who are incentivized for a variety of political reasons to commit to really an illiberal definition, while the courts remain the best hope of resistance to that. I don't know how much faith we can really put in the courts, but that's where we are at to date. There have also been attempts, not very good attempts, I would say, but there has been an attempt. I would like to see better attempts at deploying anti-discrimination law in the service of protecting pro-Palestinian speech. It all too often gets categorized as political speech, and political orientation is not a protected ground of discrimination for most purposes, in most jurisdictions in Canada. So there has been an attempt to argue that pro-Palestinian advocacy, or that opposition to Israeli apartheid, is a creed. Creed is the ground, and creed is recognized as broader than religion, and as different from politics. But what's good for the goose is going to be good for the gander, as we say, and it's quite likely that if commitment, so in the case that I'm talking about, where SIA, Students Against Israeli Apartheid, brought a complaint based on anti-Palestinian racism. Now, this was like 10 years ago, before anybody was talking about anti-Palestinian racism or discrimination in that manner. And the problem, if you want to call it that, the problem was that the leader of SIA was actually Jewish. And many of the members were not Palestinian identifying. And the tribunal took a very kind of narrow approach and said, essentially, if you're not Palestinian, you don't really get to claim ethnic identity-based discrimination protection or religion or creed-based discrimination protection. It looks a lot more like a political opinion. But if we get there, and anti-Palestinian racism or pro-Palestinian advocacy gets recognized as a creed, I think we'll also see Zionism recognized as a creed. But I think we'll also see anti-Zionism recognized, would have to be recognized as a creed. And the thing that has struck me since October 2023 is not the extent to which strongly pro-Israel identified students on campus are asserting that they feel a sense of risk or that they're in danger, because they've been quite loud about it, and they've had institutional voices supporting them and amplifying them. What I've been much more struck by are the quiet whispers of fear that I've heard from anti-Zionist white-presenting Jewish students, privileged white males who are worried about their privilege being disrupted if they come out of the closet as anti-Zionist. I work in a law school where many of my students are in their mid-20s, looking to establish, spending high tuition and looking to establish careers. And I'm having these odd conversations with people who enjoy some degree of privilege, but also face some risk of disadvantage about whether and how they ought to demonstrate solidarity. And they're finding ways to do it. And it's been quite remarkable to see disparately situated students coming together. The visible Muslim students have basically gone all in on their pro-Palestine advocacy. I think they realize that things about them are being assumed, and so I'm seeing way more keffiyehs and symbols of Palestinian resistance on the bodies of students in university than I've ever seen, which maybe is part of the reason why Zionist students or some Zionist students are claiming to feel unsafe. But I think that a student environment where people are expressing themselves openly is a good thing. People are not expressing themselves openly. Some people are expressing themselves openly, and many people are silencing themselves, and that is something that's been of a great concern to me. I work full time in a university environment, so that's my point of reference. I have more that I could say, but I also realize we're trying to keep these initial remarks to about 10 minutes, so maybe I'll bring those into the discussion a little bit later. I can stop there for now. Thank you.
Excellent. Thank you, Faisal, for this excellent overview and laying out the differences and similarities between the US and Canada, but also for these intricate details surrounding the application of law and self-censorship. I think this is very interesting to get back to in the discussion. But now we'll give time to Layla, who will address the situation in Europe. Europe is a much larger context with different countries with their own legal systems. So you have a big challenge, Layla. Same questions to you. Go ahead.
Yeah, well, first of all, thank you very much for inviting me to this powerful event. I will actually get back to what Faisal was just talking about in terms of the self-censoring towards the end of my short presentation. But I will first start by introducing the ELSC. Then I will speak of patterns of repression in Europe and give a short analysis of the mechanisms of silencing, many of which have been already mentioned in the US and Canada context. And then I will end with a short personal note about the repression that I have experienced in Berlin. However, I am not a lawyer myself, so I will not be speaking about litigation in too much detail. So, okay, at the ELSA, we're movement lawyers. We are accountable to the Palestinian civil society organizations and the Palestine Solidarity Movement, which means that we use the law in a pragmatic way, being aware of its critical aspects of law, which makes it exploitative. But we also acknowledge that law is used as a tool of oppression, but we do believe that we can use it as a tool of resistance, which can mobilize people as well. In our defend work, we act as a filter between clients and lawyers. So we offer co-counseling and expertise. We have a division in between offensive and defensive cases. So our offensive cases are cases in which we try to hold the actors responsible for the repression accountable. And our defensive cases are the cases in which we're dealing with the damage of the attacks against activists and scholars, etc. I personally, however, work in the monitor sector of the LSC, where we have collected over 700 incidents of repression in the last 3 years, excluding the more than 800 incidents that we have collected since October 7th of 2023. But as was mentioned before, the repression of the Palestine Solidarity Movement, and as the numbers also show, did not start on the 7th of October. The difference in the numbers that we have is also due to the difference in data mining. We've put a lot more resources into tracking and monitoring the repression after October 7th. So it doesn't mean that it wouldn't be as much before. And as Maria also mentioned before, the increase in repression also shows the increase in mobilization. In Europe, we are seeing since October 7th, but before, that it follows the colonial pattern of denying the past and present of the colonized. The denial is aimed at the destruction, distortion, and disfigurement of the Palestinian identity and experience. The kind of repression we're currently seeing in Europe is a manifestation of its decades-long attempt to connect the Palestinian identity and experience to terrorism and anti-Semitism, which are the main allegations used still. But also, as Tamara, you mentioned in the beginning, the repression of Palestine solidarity did not start with the bombardment of Gaza. So the incidents that we've been monitoring, the mechanisms of silencing that we've been monitoring have been put in place way before the 7th of October, but there's some differences now, which I will get to after explaining what the mechanisms are. At the ELSC, we have identified 15 mechanisms of silencing, which we can track, though in different degrees across countries. One of them, of course, is threats of legal action, where the police and also like the policies that are being put into place by the governments aim to criminalize and to, state sanction the Palestine Solidarity Movement. We also have, of course, cyber attacks and surveillance. Surveillance can be physical as well, not just online. We have smear campaigns. This is, of course, a classic one in which there's a public character assassination in mainstream media or also on social media to isolate an individual from society and to make it very difficult for them to continue with their careers or for their statements to be seen as credible. There's potential disciplinary investigations or also the potential disciplinary investigations at institutions of employees and students, which scares many of speaking out. In the UK, we've seen a very worrying development of disciplinary investigations where the speed is really insane. There's always been in the UK disciplinary investigations against students at universities and professors, but since October 7th, we're seeing an insane speed at how it happens. So for example, a student posts something about Palestine at 5 p.m. on an evening, and the next day at 9 a.m., they are already being called into a meeting with the administration surrounding that post. So the speed that we're seeing is new, but the mechanism itself isn't. We also, of course, have monitored several refusals or withdrawals of uses of venue or cancellations of events. When events happen, there have been physical interferences with events, either by security or police, but also by pro-Israeli groups and some other groups across Europe. usually Islamophobic groups. There's of course attempts at defunding, approaching the donors so that they take away their funding from Palestinian NGOs. Financial de-risking, where banks close bank accounts or halt the transactions of Palestine solidarity groups or Palestinian individuals because they fear to risk like breaching the anti-terrorism and financing and anti-money laundering legislation of the EU. So it is often quite a racist application of that legislation on Palestinian groups and people, where they say that it's due to compliance reasons and it's very difficult to challenge them because they usually don't they don't cite this EU legislation, despite it being often clear that it's because of this that they're closing the accounts. We also have, of course, online deplatforming, where online content and accounts, social media accounts, are being closed or restricted or censored. Restriction of movement, also often, which comes often hands in hand with racist applications of security, and especially, of course, in the EU, the borders are open, but Palestinians or Arabs in general often have a lot of trouble crossing borders despite having valid papers. But also in terms of their entrance to certain buildings, etc., they're often being checked just for looking Arab. We also have harassment, intimidation, or violation, violence, which happens through often from police brutality, of course. That's the main incident that we have under this incident type, but also from individuals on the streets, people being spit at, screamed at, often also violently harassed by bypassers, often because of wearing a kufi, having a flag, or some symbol that relates to Palestine. What we've also seen across all countries is a very big increase in loss of employment or suspension from positions after individuals have spoken out about Palestine on their workplace. Those are a lot of the cases that we deal with, as well as threat to citizenship or residency status. This one is very worrying right now, especially in Germany, where refugees who have been in Germany for years are being targeted by the migration office, and if they're politically active in organizing protests, etc., they're being threatened to be deported and their refugee status to be suspended. Whereas Palestinian students, for example, go through intense questioning whenever they want to renew their student visas about Israel, etc. Then, as Faisal was also mentioning, we have, of course, threats to academic freedom, in which academic content is being interfered with, or there's this chilling effect in university settings to not speak about Palestine, not to mention to write a thesis about it or speak about it in public events, for example. And then we have something that we call bureaucratic obstacles, which is, for example, very present in the Netherlands, which is a bit more liberal than, for example, Germany and Austria. In Germany and Austria, the authorities and administrations at universities, for example, will straight out tell you you can't talk about Palestine, it's anti-Semitic, etc. Whereas in the Netherlands, what happens is that they do not tell you that it is about the topic, but they bring out bureaucratic obstacles to make it very difficult for you to go through with the event. So what usually happens is that 2 days prior to the event, despite it having been registered a month before, they come with some certain conditions that are impossible to be met by the time of the event, so that the organizers themselves have to cancel the event. So yes, what we're seeing right now is an unprecedented increase in repression by us having monitored each one of these incident types across countries in huge numbers. But at the same time, it is also the continuation of a trend that started 5 years ago in Europe, partially due to the success of the Palestine solidarity movement in challenging the unfounded allegations of anti-Semitism and support for terrorism. So now what is happening here is that they're claiming a breach of law or policy instead. And this happens with the IHRA definition, where a definition of anti-Semitism, where 7 out of the 10 parts of it refer to Israel, and are applied, of course, in all disciplinary investigations. For example, in the UK, most universities have adopted the IHRA definition, leading to the disciplinary investigations. But also the anti-BDS motions that we're seeing that have been passed already years ago in Germany and Austria, which prevents any BDS-related group or any speaker who spoke in support of BDS at any time to speak publicly. So the BDS groups can't have access to city venues, nor can people who spoke in support of BDS speak publicly in institutions or any other places hosting events. Of course, all of these bans and restrictions are often justified with racist arguments, which is not surprising considering the rise of far-right parties all across Europe, which have consistently dehumanized migrants, refugees, and Muslims in European foreign and internal politics. Now, Faisal before was mentioning something really important, which is the chilling effect, which comes out of all of these incidents of repression. So, of course, when students, for example, or anyone sees the smear campaigns in the mainstream media of anyone speaking about Palestine being attacked for being anti-Semitic or a supporter of terrorism, it creates a chilling effect that deters others from speaking out on Palestine. Faisal also mentioned the anti-Palestinian racism, which is a form of institutionalized anti-Arab racial oppression that silences, excludes, erases stereotypes, defames, or dehumanizes Palestinians and their supporters for narrating their lived experiences of oppression. So what anti-Palestinian racism does, and this is also, as was said before, why it is often applied to non-Palestinians as well, is that it slanders them as inherently anti-Semitic or supportive of terrorism, which is evidenced in Europe by a very long list of academics, artists, journalists, and activists, especially but not only Palestinians and other Arabs, that have been subjected to public character assassinations and smear campaigns, as well as censorship and exclusion from speaking out or campaigning for Palestinian rights. These attacks altogether serve the purpose of creating this chilling effect, but it also isolates the Palestine solidarity movement from other anti-racist movements in Europe. I'm just going to give a few incidents, a bit of information about a few incidents in Germany, because this is the country in which we have monitored the most attacks recently, but that doesn't mean that it doesn't happen elsewhere. It's although it is at a different level in Germany. So as a Palestinian German myself, I find it unbearable to be in that country due to its complete denial of Israeli crimes and attempts to erase the Palestinian identity in all spheres of society. I was working from Berlin in October and November 2023, where I initially went there to document the repression in May, because the Nakba commemoration events had been banned and brutally suppressed by the police. So way before October. Needless to say, I didn't get to these interviews. I was very busy with documenting and monitoring the repression that was happening in October, because there was a ban of all Palestine-related demonstrations and events from the 7th of October to the 25th of October. And in those weeks, I have experienced repression, which reminded me a lot of the colonial policing back home. So I'm just going to give a few events back then that occurred. So for example, due to the demonstration ban, any group of people wearing kufiyas was seen as a violation of the demonstration ban. And they were either fined or also often arrested by the police in very brutal ways, including children who were walking around with a flag, or also had stickers or a Palestine patch on their backpack or something, were also being detained by the police. The Berlin Senate of Education and Youth and Families actually sent out an advisory policy to all schools in Berlin, advising the supervisors or telling the supervisors to not allow any of the students, and this is to primary schools, by the way, not even higher schools, but they were telling the supervisors that they need to repress any Palestine-related symbolism on campus, on the school buildings. So kufiyas weren't allowed, flags weren't allowed, stickers or anything Palestine-related wasn't allowed in schools. And they were also told to call the police if students would do it regardless. There was also an Indigenous Day protest which was allowed because it was an anti-colonial protest in general, mainly by Latin American groups. And as soon as the Palestinian flag was at the protest, the police told the organizers that Palestine is not allowed to be at this demonstration because, according to the police, it has nothing to do with the colonialism. The police entered that protest very violently, arresting everyone who had a Palestinian flag, as they did in other places throughout the month. However, I can keep speaking about the repression in Germany and Europe for hours, so I will stop here.
Thank you so much, Layla, for this very useful overview of the mechanisms of repression and silencing in Europe, and for covering a number of different countries. Before we move on to the next round, I think maybe I can follow up with all of you with a couple of questions about what we've discussed. You both mentioned a lot of similar mechanisms and tactics of repression, but also two things really jumped out at me. One of them is the chilling effect, which seems to be the most effective in silencing and deterring people from speaking out, and maybe isolating Palestine rights activism and advocacy. And what can be done about this? Is there anything that can be done about this legally or in other ways? Just give each of you maybe a minute to give us your input, and we'll follow the same order. We'll start with Maria, and then Faisal, and then Layla. Maria, go ahead.
Sorry, could you just repeat the question? What can be done?
About this chilling effect, this environment of fear where people are afraid to speak out.
I think the main thing really is offering people support, and that's why all of our organizations are so critical. Including Palestine Legal. I think knowing your rights going in. I think talking to organizations, reaching out to in the United States, reaching out to Palestine Legal for support. There's safety in numbers and in collective action. And really fighting back and not being chilled, and knowing the most important thing, morally and otherwise, is to be standing up for Palestinian rights and against genocide at this moment, and keeping things in perspective. And I think other people can be offering support, financially as well to people who are feeling the consequences of their activism. So I guess, yeah, I'll leave it there.
Thank you, Maria. Faisal, do you have anything else to add?
Yeah, I would echo that. I think you need to fight fire with fire. There's no other way. And so your enemies win if you allow yourself to be silenced. That's my general approach. At the same time, personally, at an personal ethical level, when I'm advising individuals, I'm very aware that the the potential price that I pay for having a big mouth is not the same as for many other people. So I think there's also a principle that solidarity requires some careful calibration, and so and good support. So before telling people to fight, I think you need to support people. You need to know their position, and you need to let people make decisions for themselves. And I think through empowering people and letting them, I mean, a lot of the people that I'm meeting are young people who are encountering this for the first time. So even just sharing my own story, my own experience, and affirming their position, affirming their fears, their concerns about potential consequences, not lying to them about potential consequences because it's real, but also letting them know that we have a movement and that we have greater support than we have ever had for this. And some people make great test cases and some people don't. And so we as the lawyers and the activists working in this need to be responsible, and we have to care about people as much as we care about the cause and make careful decisions. But I've been really inspired by what I've seen. We're doing all of these things better than we ever have before in my 25 years being an activist and offering support to others who speak out on Palestine. It's come at a terribly high humanitarian cost in the region, but in terms of advocacy successes and potential, these are in a strange way kind of hopeful moments.
Thank you, Faisal. Layla, do you have anything to add?
Not much, but I think, actually the most important part is community, to build communities and also to reassure everyone who wants to speak out or who has faced repression when speaking out that they're not alone. Smear campaigns and other mechanisms of silencing actually aim to isolate someone from community so that they don't feel like they can go against it. And this is, as Maria said, also why our organizations exist in the first place. So yeah, it is always the most important thing is to go through it together, to be there for each other when it happens, and also to be confident in the sense that none of the accusations or mechanisms are new. I would say, as the Palestine Solidarity Movement and allies of Palestine worldwide, we're very well practiced and have a lot of access to different resources which can guide us through the repression and also encourage us to not back down.
Thank you to all of you. The second point that I just want to follow up on that all of you mentioned is the IRA definition of anti-Semitism, which is being, it essentially conflates anti-Semitism with criticism of Israel, and it's being used, even though has not been adopted at higher levels yet. It's still being used and applied for all intents and purposes to criminalize, any work for Palestinian rights advocacy or criticism of Israel. What is your assessment of the prospects for the adoption of the IRA definition of anti-Semitism in your by different governments in your respective contexts? And how can this be, in a way, challenged legally? We'll start with Maria again.
Well, I mean, it is, I mean, kind of like Faisal said, it's been adopted to different extents. One thing Trump did was issue an executive order requiring executive agencies to consider IRA in enforcing Title VI. What's happening right now is a decision whether DOE Office of Civil Rights should codify it. There is, IRA definitions have been adopted in at least Florida and maybe elsewhere. I think there can be First Amendment challenges to the definition, to the use of the definition. I do think also, though, again, this is a narrative war. This is a fight about what is anti-Semitism, and a lot of the struggle needs to happen at that level, explaining to people why opposing Zionism and advocating for Palestinian freedom is not anti-Semitic, but that there should also be, legal fights as well.
Thank you, Maria. Faisal?
Yeah, I think if it wasn't for a concerted effort by a ragtag bunch of local activists, both from within the Palestinian community, but especially like some formidable work done by an organization called Independent Jewish Voices, IJV, which is the Canadian equivalent of Jewish Voices for Peace in the United States. They really stepped up and defined themselves in relation to IRA. They're a pretty recently formed organization, but they're one of the few organizations, I believe they're the only organization on the other side of the Israel-Palestine advocacy debate that has funded staff members. To the best of my knowledge, so far, none of the Palestinian organizations, including the Legal Center for Palestine, have staff members. We're all run by volunteers, mostly lawyers who have busy practices. And that's a huge disadvantage. But IJV took their resources and their dedicated staff and invested it in opposing IRA. And they were actually world leaders. Those of you that have worked on anti-IRA work, I am sure you've consulted their excellent resources that they produced. And without that, we would have it. There was in Ontario, the largest, most populous province where I reside, where the capital Ottawa and the biggest city Toronto are. It was by a hair that a conservative government abandoned its effort to adopt a statute that would codify IRA. It used a different route that created some legal ambiguity that had kind of lawyers wringing their hands. But this is in a way a success of the pro-Israel lobby to be able to say, and they do say, that it's been adopted. They even try to argue that it's enforceable. We've seen municipalities, mayors, who have quite a lot of jurisdiction on their own within their jurisdiction, within their limited jurisdiction, to adopt and impose IRA as a municipal matter. And so there have been, but then the resistance to that, led by Independent Jewish Voices and pro-Palestine advocacy organizations, was also formidable. And so we saw municipality by municipality these battles going on over IRA, city council votes across the country. This was all happening really 4 to 5 years ago. But the battle will continue because the pro-Israel lobby voices are really pushing IRA hard to be adopted as part of the anti-racism strategy, as part of a new anti-Semitism strategy, and at every level of government policy. And it's the one issue that there is absolutely no difference between the conservatives and the liberals, the two dominant political parties, that they agree completely on this issue. And the prime minister has been outspoken in condemning BDS, in supporting IRA. And so it's at the political level, it's very worrying. So far, the rule of law is there and can be used. But at the end of the day, I agree with Maria that there's only so much work that the law can do to prevent the enforcement of a definition that, where if all the political actors want to define a concept in a particular way and want to enforce that in law, it's going to be very difficult to resist that using only the law.
Thank you, Faisal. And I'm sure, Layla, you've experienced that in Europe as well. The role of politics in that. Can you tell us a little bit more about it?
Yeah, I mean, similarly to the US and Canada, it is also non-legally binding in Europe. However, it has still been adopted by several institutions, especially universities, despite it not having been intended to be a hate speech code for campuses, it has in effect become that in the UK. At the ELSC, we have published a report in which there's 40 cases where university staff members or students have been accused of breaching the IHRA definition. And out of the 40, 38 cases were dismissed. 2 weren't because they're still ongoing. However, this also just shows how inapplicable the IHRA definition actually is when it is being legally challenged. And in those cases, the trumping legal argument was that it is just a violation of freedom of speech because it referred to Israel actually and not to anti-Semitism at all. And this misuse has actually also been criticized by the former UN Special Rapporteur on Racism, as well as the Human Rights Watch and Amnesty. So it is actually a definition that if you legally challenge it, it has a very weak standing. However, the problem is that it is still effective in terms of the chilling effect. And the disciplinary proceedings alone are very worrying and cause the people subjected to them to be hypervigilant and under a lot of stress during these investigations. But yeah, this is why we do encourage people to legally challenge them, but it's not always possible, and people don't always think of doing it. They often retract their statements instead.
Thank you, Layla. And now I'd like to move to the second round of discussion, switching topics slightly. We've been hearing about how laws are being exploited as tools of repression, and the limitations of laws, especially when it comes to political will and political influence. But also legal systems can be used as tools of accountability. And this is going to be the topic of the second round of discussion for this session today, government complicity in Israeli crimes and avenues of accountability. I'd like to ask each one of you to address how Western governments and allies of Israel, who have been providing it with military, financial, and diplomatic support during the last 6 months of the war on Gaza, but even before, how can they be considered complicit in Israeli crimes in the legal sense? And what legal measures have your organizations taken? And how can these governments be held accountable for their role in this genocide? Again, I would like to start with Maria. Maria, the Center for Constitutional Rights has filed a lawsuit in U.S. federal court against President Biden, Secretary Blinken, and Secretary Austin, Secretary of Defense, for their failure to prevent and complicity in the Israeli government's genocide in Gaza. Could you tell us a little bit about this case as well as other cases that you're working on? Maria, go ahead.
Yes, thank you. So the U.S. government's unconditional and extensive support of Israel's genocide of Palestinians has really made it Biden's genocide at this point, with U.S. money, weapons, diplomatic cover, a complicit Congress, a complicit media, complicit weapons manufacturers in the United States, complicit U.S. states, and complicit universities, like we just talked about. So the U.S. is by far the largest exporter of arms to Israel. We're sending Israel weapons while it blocks humanitarian assistance in order to starve children to death, despite ICJ provisional measures, despite the federal court decision in our case, which I'll talk about, and despite a Security Council resolution demanding an immediate ceasefire. So going back to October, October 18th, CCR issued a briefing paper laying out the factual and legal analysis for Israel's intent to commit genocide and its genocidal acts, as well as U.S. complicity and its failure to prevent. And we sent it to top U.S. officials, UN officials, Congress, Karim Khan at the ICC, obviously with no real response. A few weeks later, in November, CCR and our co-counsel Vanderhout in San Francisco brought a case in federal court in California on behalf of Palestinians as you said, against Biden, Blinken, and Austin to stop them from aiding and abetting genocide and to force them to comply with their legal duty to take measures to prevent genocide, which was triggered as soon as the U.S. learned that there was a serious risk of genocide. So we represent two Palestinian human rights organizations, Defense for Children International Palestine and Al-Haq, which is the oldest human rights organization in Palestine. We also represent 5 Palestinian Americans in the US whose family members are being killed by Israel in the hundreds. Their homes and neighborhoods are being destroyed, and this is all supported by our own government. And we represent 3 Palestinians in Gaza. Mohammed Abu Rakhba is a field researcher for DCIP. He was displaced several times, and his family is now living in a tent in Rafah. His mother was shot in the leg in the north, and he wanted to evacuate her. So DCIP called the Red Cross, and they basically said, we have tens of thousands of cases like this. There's nothing we can do. Ahmed Abu Artima is another client. He organized the Great March of Return. He was at his father's house when Israel struck it, killing his 12-year-old son, Mohammed, and his 10-year-old niece and 4 other relatives, and he and his family members were severely injured. Our third Gaza client is Dr. Omar Al-Najjar, who's a doctor who's been living and working at a hospital day and night, receiving the dead, the wounded, the sick. On Eid, he went to see his neighborhood in Gaza, and it was completely destroyed. He couldn't even get to his street because Israeli forces were, ready to shoot at anyone if they approached. So those are the clients we're representing. We filed our complaint. We also filed what's called a preliminary injunction motion, asking the court to urgently stop the U.S. from providing further military support to Israel's attacks and the siege, even before there's a final determination in the case. So we were able to file declarations from our clients, from a leading genocide expert, William Shabas, from Barry Trachtenberg and other U.S. genocide scholars, and from Josh Paul, who is a former State Department official who resigned in protest at the vast amount of military technology and capability that the U.S. provides Israel, knowing it'll be used contrary to U.S. and international law. We had several amicus briefs filed on our behalf. Defendants, of course, opposed, our motion and moved to dismiss the case. They didn't contest that Israel's committing genocide or that it's knowingly aiding and abetting it. But they basically argued the court doesn't have jurisdiction, the clients don't have standing, and arguments of that nature. So because we had a preliminary injunction motion, we were able to ask for an in-person hearing to put on live testimony in support of it. And the week before the hearing, the court granted our motions over the government's objection. So our hearing was actually the same day that the ICJ issued its historic provisional measures. We had a hearing in Oakland with 1,000 people on Zoom because that was the court's limit. And our Palestinian clients testified about the genocide being committed against them with U.S. complicity, about the Nakba. They created a really powerful historical record, which was recorded and is on the court's website that everyone can watch, forever. So I encourage people to watch it. It was nearly 4 hours, the hearing. Dr. Omar from Gaza started us off on Zoom, basically standing in the hallway of the hospital outside the administration office so he could get Wi-Fi. And while he was waiting to testify, there was an airstrike on the tents of displaced people in Rafah, where his sister family is living. And he had to leave to go help and to check on the wounded and basically to make sure his sister and nieces weren't among the people coming in. So 4 of our clients in the U.S. also testified. One of them had another relative killed while we were on break in the court hearing. And then representatives from DCIP and Al-Haq also testified. So the judge was incredibly moved and engaged. He said it was the most difficult case he ever had, factually and legally. He was troubled that there's no forum that has jurisdiction over U.S. officials to enforce the binding international law forbidding complicity with genocide. But less than a week later, he issued his decision. The good parts of it are that he found Israel was plausibly committing genocide, as the ICJ had done. He implored the U.S. to examine the results of its unflagging support. And he said it's every individual's obligation to confront the siege in Gaza. But although he said he preferred a different outcome, he decided he didn't have jurisdiction to adjudicate the case. He found the case challenged the appropriateness of providing financial and military aid to Israel, which he found challenges foreign affairs, which he found is a political question for the executive, not for the court to decide. So we've appealed that decision, and we've been granted an expedited schedule. We're arguing, what he found was on the political question doctrine. We're arguing that it is actually the constitutional duty of the judiciary to decide whether or not the U.S. government, whether or not these defendants are complicit in genocide. And the court shouldn't be abdicating its role. It's its job to say what the law is. It's not a doctrine of impunity. We're not asking the judge to assess the wisdom of discretionary policy choices. We're asking the court to uphold binding legal obligations. And it's not within the executive's discretion to aid and abet a genocide here. And basically, if you take the defendant's argument to the logical conclusion, they could commit genocide and the courts could not hold them accountable. So we had eight friend of the court amicus briefs filed in support from NGOs around the world, domestic human rights groups, legal scholars, former military leaders and diplomats, all arguing that the district court's decision should be reversed. So we've received defendants' brief now. They've doubled down on their arguments, and they're renewing their arguments that plaintiffs don't have standing because the U.S., they say, isn't responsible for plaintiffs' harms. Israel is, and the U.S. can't stop Israel, so a court decision wouldn't help. And we have our reply brief due soon, and the appellate argument is June 10th. And you can see our website for more information about that, and that will also be live streamed, that argument. So that's, focusing on U.S. complicity in genocide has really been our focus. There are other ways, which are things that people are looking into. We've traditionally been able to sue foreign Israeli officials for war crimes, genocide. It has not been successful, but that doesn't mean it's not time to try again. Same thing with arms manufacturers who are complicit. Right now, we've been really focused on the U.S. officials. So, and hoping that this case can really, shift the narrative, help raise awareness, be used for activists, not only to create a historical record, but to actually put more pressure on the political leaders to reverse course and do something about this genocide. So thank you.
Thank you, Maria, for this important information and for the important work that you're doing in your persistence. We invite everyone to check out the updates on the case on the Center for Constitutional Rights website. Next, I'd like to move to Faisal and the situation in Canada. We've seen some legal action in Canada in the last few months. On one hand, as far as I know, some Palestinian Canadians are suing the federal government and the foreign affairs minister over military exports to Israel. And then on the other hand, the relatives of the Israeli victims on October 7th are suing the Canadian government over funding of UNRWA. So if you can give us your assessment on how can legal measures can be taken or attempted in Canada to hold government officials accountable.
Sure. Yeah. That lawsuit brought by some pro-Israel groups pertaining to Canada's decision to reinstate funding to UNRWA. I've had a chance to look at the notice that originated that. It hasn't really gone anywhere yet, but it looks to me like classic lawfare, in that it is making quite a strong claim with very little underlying merit. But I know that the community is taking it seriously, and I know of at least a couple of groups that intend to intervene in that case and to remind the court of important principles. So in terms of holding the government to account, certainly we in Canada have been slower than others We've seen what activists in the Netherlands have done, and that was inspiring, actually. That inspired, I would say, a copycat litigation that I'll talk about in a moment. And we were inspired by what the CCR have done in the United States, and that inspired a copycat litigation that I'm involved in. So let me just say a quick word about the copycat of the Dutch litigation, which is a lawsuit against that's brought on behalf of Canadian Lawyers for International Human Rights, Al-Haq, the Palestinian Human Rights Organization, and 3 Palestinian Canadian individuals challenging the Canadian government's arms sales to Israel, specifically seeking an order from a court that export permits be seized pursuant to legislation that permits the issuing of export permits for military goods and technology, and makes it conditional on those exports not being allowed to be used where there's a substantial risk of grave violations of international law. So the argument is that the facts now are pretty clear that there is a substantial risk of grave violations of international law, if not the actual existence of grave violations of international law. And so on that basis, this lawsuit appears to have merit, and almost instantly it yielded some outcomes, as the Canadian government has publicly committed to not issue any new export permits. But of course, that was a little bit of was criticized as being a little bit tricky, because the government did not commit to ending already issued export permits, and so it appeared that there was a good number of shipments that would still be sent off. The government also used some language around appearing to draw a distinction between kind of military adjacent equipment, like armored vehicles, for example, which would be apparently not deployed for combat use. But the claim is much broader than that, and is essentially saying that any technology or equipment that is used by Israel for any purpose, really, whether it's for domestic policing or for direct occupation, is complicit in the war crimes, and is seeking a declaration of that all such permits are unlawful, both under the relevant legislation, the Import-Export Permits Act, but also under the Canadian Charter of Rights and Freedoms. And so they're relying on Section 7 of the Charter, which protects the right to life, liberty, and the security of the person. So that will be interesting to watch. I think the mere fact that the litigation was brought has had some political has already brought some political value, whether the case wins or not. And I think it's important to mention that there can be considerable value in bringing cases that are likely to lose. Sometimes bringing losing cases can be very dangerous, because you can get a legal finding that sets you back. But sometimes bringing a losing case can bring success outside of the court, even where there is no success in the court. Just actually on that, I would refer back to a way in which that was used very usefully a couple of years ago. There was a scandal at the University of Toronto after an individual named Valentina Azarova was offered a position to run an international human rights law clinic, and after a right-wing Israeli academic made a phone call to a right-wing Canadian judge, who made a phone call to a well-positioned academic administrator at the University of Toronto. You can see how, being a small country with small networks, this is part of what I was alluding to earlier. The downside of that is that in a matter of hours, a right-wing Israeli academic was able to have a hiring decision at the University of Toronto canceled. And it was only by litigating the case in what ultimately proved to be a loser of a case that we were able to obtain disclosure of all the relevant information that presented us with all of this background information about what was happening behind the scenes that we did not actually know at the time, that could only be inferred or assumed. There is now a very thick evidentiary record of communications such that we can understand how the Israeli lobby works and how improper decisions are taken, and it's a way to shame and embarrass people in high position. The dean of that law school, I don't think his reputation will ever recover from that scandal. Okay, so the second thing I wanted to talk about is the case that was inspired by the Center for Constitutional Rights case. It's not identical, but it is targeting Canadian officials for complicity in genocide, specifically for failure to prevent genocide. So under Canadian law, unlike most international instruments, we have actually incorporated the relevant aspects of the Genocide Convention into domestic criminal law, which unlike in the United States, applies federally. We have a single criminal law for the entire country, so that makes it also quite a little easier. So it is domestically criminal to engage in war crimes or crimes against humanity. And so we, using both the Genocide Convention and the duty to prevent, as well as the Canadian Charter of Rights and Freedoms, we've issued a demand letter to the Prime Minister and a number of officials demanding that they do something to fulfill their legal obligation to prevent genocide. And we point to the things that they have not done. Canada has not stopped, had not at the time stopped shipping arms, and it appears still has not stopped shipping arms to Israel for the reasons that I mentioned a moment ago. They've simply canceled export permits going forward. Canada has not stopped Canadian citizens and permanent residents from going to serve in the Israeli military, even though it's a crime in Canada. It's just a crime that's not enforced when it comes to the Israeli military. Canada has not withdrawn its Canadian Special Forces, which are on the ground. We have very little information about what they're doing, but we know that they're collaborating with the Israeli military, and we say that makes them complicit in genocide. Or in presumed plausible genocide, and the government has done nothing to review the charitable status of organizations in Canada that provide material support to Israel that we fear is supporting plausible genocide. And so by highlighting the things that Canada has failed to do, and the fact that Canada has done actually nothing, in addition to the fact that Canada suspended UNRWA funding, although it appears it has since reinstated that, we are going to argue. The case has not begun yet. We've, as I said, have just issued a demand letter, but we intend to commence an action shortly, seeking a declaration from Superior Court that the government has failed to fulfill its duty to prevent genocide. We're asking for a very limited remedy. That is a declaration. And we talked a lot about this as lawyers and thinking about seeking a small victory versus seeking large victories and the strategic questions that are at play. And I'd be interested in other people's thoughts on the similar question. But ultimately, we decided to go for the most attainable remedy possible, which is a declaration from the court, and then to build from there. And so, I think I'll leave it at that. Thank you.
Thank you, Faisal, for the information and the important work. And it's an interesting point about small victories and what's more realistically attainable in situations like this. And it would be interesting to hear the perspectives of others on this as well. But let's move to Layla first and the situation in Europe, accountability for government complicity in the genocide. There are some cases that are piling up to stop weapons exports to Israel. Faisal mentioned the Dutch case in the Netherlands. There's also Germany, Denmark, France, and the UK. Can you tell us a little bit more about those and any other attempts Layla, in Europe? Go ahead.
Yes, so Germany, for example, is the second largest weapons exporter to Israel after the US. And in 2003, actually, the weapon export, like the arms exports from Germany to Israel, actually increased tenfold, which is why in late February, the LSC, alongside Palestinian families in Germany, filed a criminal complaint against German state officials, specifically Baerbock, Scholz, Lindner, and Habeck, for aiding and abetting genocide. However, apart from the approval of more than 300 additional export applications of military equipment to Israel worth over 300 million euros, the aim of the urgent motion by our lawyers was also to immediately stop future approvals of weapons of war deliveries to Israel and revoke approvals that have already been granted. So similar to the cases that have been mentioned before. It is too soon to say how this case will be dealt with in Germany. However, as Faisal said, we do believe that even if we would lose this case, because the German officials are already saying they have no idea that any weapons are being exported to Israel, and that it's like going to be more of a company corporate matter than a state matter. It is still important to say that even if this case would be lost, it is a political win because it brings light to Germany's complicity in the genocide in Gaza. But what was also mentioned before is the case in the Netherlands, where I will go a bit more into detail. So in early February, the Dutch Court of Appeal ordered the Netherlands to stop weapon exports of F-35 fighter jet parts to Israel within 7 days, which was a huge victory with serious spillover effect as well for other potential cases, as was mentioned. The court ruled that it was sufficiently clear that there's a risk of Israel violating international humanitarian law norms in Gaza, and that the government failed in its the Dutch government failed in its assessment of the matter. So the judge also stated that there is a clear and evident risk that Israel is violating international humanitarian law in Gaza, which is a big win already to have that being stated by the highest Dutch court. But also the risk that the judge also confirmed the risk being crucial in determining whether or not arms exports should be stopped and trumps other considerations like relations with allies and economic reasons in the Netherlands itself. So we hope that this case also will be of a motivation in other EU jurisdictions to halt the export of weapons. But we also hope that the cases that are being brought forward in Europe will also highlight the incitement to genocide within European societies themselves, calling for and supporting the attacks on Gaza, whether at the state level or in the media or any public spokesperson, for example. Then there's the March 30 movement, which I will briefly mention, who are actually holding accountable the Israeli soldiers in Gaza, which have a dual nationality with one of the European countries. And there's direct criminal charges for their complicity in war crimes being brought against them as individuals in several European courts.
Thank you very much, Layla, for this. You've raised a lot of important issues that I think we'll follow up on in the questions. I'll do one round of questions and then hear from all of you, and then we'll take a few more questions. But quickly to follow up on the last point that Layla made, for dual citizens, Israelis who participated in the recent war and genocide in Gaza. What are the potential avenues for accountability for those dual citizens when they come back to, or even without coming back to the US, Canada, and some European countries. And what are the prospects for holding those to account for, investigating their crimes and charging them? So that's the first question. The second question I'd like to ask is one from the audience. An audience member is asking, have you witnessed shutting down or closed government monitoring of associations advocating for Palestine in the US and Canada, similar to what happened in France? Are there differences in the way Canada and the US have dealt with these associations? I think this is the question that specifically asks about the government's involvement in this type of direct government involvement in this type of repression. Another question is about your own organizations. Have you faced or experienced any kind of intimidations or attempts to close your organization? We'll take this round of questions, and then we'll maybe give a few minutes to each one of you to answer whichever one you feel more strongly about, and then we'll take another round of questions. Maybe we can start with the same order as well. Maria, go ahead.
Thank you. One thing to note about the difference in the United States than other places is we do have federal criminal laws in the US that make genocide and complicity in genocide and war crimes federal crimes. We just can't do anything about it as private citizens. The Department of Justice enforces the criminal statutes. So we can ask for them to prosecute, but it's unlikely at this point. But genocide has no statute of limitations, and most war crimes in the United States don't either. So I think we can at least leverage the fear that, when political will changes at some point in however many decades, maybe there could be prosecutions. We just to mention, and this would be, these laws would apply if the offender is a U.S. national, if they're in the United States. There's various ways they can apply, but they would certainly apply to dual nationals. They would apply when, Israeli officials come visit the United States. They would certainly apply to U.S. officials. And we've seen, the DOJ has brought war crimes charges even recently against 4 Russian soldiers for war crimes in Ukraine under the war crime statute. So they can do it if they have the political will. One thing I just wanted to respond with regard to what Faisal said about declaratory relief. We agree. We also sought declaratory relief in addition to injunctive relief in our genocide case. The court didn't address them separately, which it is required by law to do. So that's one of the issues that we're raising on appeal, even if for whatever reason you think that forcing the government to stop, sending weapons to Israel's genocide creates a political question. Certainly declaring that it's either aiding and abetting genocide or failing to prevent genocide can't create a political question. That's a pure legal decision. And so that is one of the things that we're pursuing. And then I mentioned, I guess, going back to the possibility of civil suits, if there are, it's a little more difficult, it's easy when you have high level foreign officials, but in order to do it against soldiers, you need to know who they are, where they are, what they've done. But it is a possibility. So I think the second question had to do with maybe sort of surveillance and investigations, I think. And we have seen, right when everything started happening, there's obviously always surveillance online and people being doxxed. There were increased FBI visits and surveillance. It felt almost like the post 9/11 era in the United States where everything was being activated. I don't know what's happened with investigations. I haven't heard much about that. It's certainly a possibility. our own organizations, knock on wood, we've been okay so far. It is one thing to be concerned about in a different administration. We obviously get lots of, feedback about our work. but hopefully not more at this point. So thank you.
Thank you, Maria. And we'll come later to the question about what a different administration after November would look like. Faisal, would you like to answer any of these questions? But also, are you aware of any efforts to document or investigate individuals, dual citizens who are involved in Israeli crimes?
Well, first of all, with respect to criminal prosecution, we have the same obstacle in that we need the Attorney General to either launch an investigation themselves, or to essentially authorize a private prosecution of war crimes or crimes against humanity. So there's a practical obstacle, but the civil suit offers some promise, because we don't see a lot of hope in persuading. Although I've been in meetings where we've attempted to bring in an evidentiary record to the Attorney General to ask for them to launch an investigation, but that ends up becoming more of a political question than a legal question, really. In terms of in terms of state repression, I'm kind of shocked by what I see happening in Europe, in terms of the criminalization of speech, the banning of organizations, the banning of but I've been shocked by what I've seen in Europe for many years, right? Like the banning of the hijab in the educational sector is just from a North American, I think it's fair to say, from a North American freedom and anti-discrimination perspective, it's kind of not really the same context at all. So I don't think that there is the risk of that kind of direct targeting by government, although like I said, our Prime Minister has publicly declared BDS to be bigotry. He equates it with bigotry, and so that puts a target on the backs of activists, and we have seen it with police repression at protests, which have been large and sustained since October, pro-Palestine protests, and they've gotten larger and more direct action. And essentially, what we have is a police that responds to the community, and what we're witnessing is the inequality in community policing, where members of privileged communities that feel threatened. So you're talking about well-established urban Jewish communities that are predominantly supportive of Israel, are able to weaponize community policing against members of the same communities, their neighbors, who are protesting for Palestine, and in a way to cast them as outsiders, to demand that they be rounded up and deported, making these false accusations that they are even subject to deportation. Most of the people protesting for Palestine are Canadian permanent residents and citizens, to the best of my knowledge. And so there is an attempt by members of the society to undermine the very democratic and rule of law protections that we have in the interest of advancing the interests of a foreign state's genocide, which is very demoralizing, to say the least, to witness this amongst fellow citizens, amongst fellow lawyers. I mean, the most vocal perpetrators of these tactics, which are completely dishonest and are completely undermining of democratic institutions, are lawyers, those who are professionally charged with upholding the democratic nature of the society and preserving the rule of law and preserving the appearance of fairness in the administration of justice. I've been completely disappointed with the bar. I don't know if what it's like in Europe in terms of the role of the legal profession in maintaining democracy and rule of law, but the way our profession is structured here, it's absolutely shameful. Even judges, one of our most revered Supreme Court justices who recently retired, published an op-ed in the most widely read national newspaper the day before the International Court of Justice hearing into plausible genocide, and ultimately which found plausible genocide. And she completely attacked. It wasn't even a well-reasoned critique. It was a full-throated attack on the legitimacy of the ICJ, on the merits and the good faith of South Africa bringing this case. So all that is to say, elites who are invested in Israel's project, up to and including genocide, are using whatever levers they have access to try to manipulate the state. I have not seen that being directly successful, but indirectly successful, no doubt. We've seen for many years Muslim and Arab charities have been overly scrutinized and presumed to be associated with terrorism in ways that other charities that are not Muslim and Arab are not. And increasingly, there is now more focus on charities that appear to be supporting Israeli militarism. There's pressure from the state on university presidents and on universities in general to suppress certain forms of speech. And certainly any community organizations that rely on public funding. And in Canada, there is not the kind of philanthropic funding that exists in the United States and maybe elsewhere. And so historically, community organizations have relied on public funding to exist. And ever since the Canadian Arab Federation was defunded over a decade ago by a conservative government that targeted them because they were outspoken on Palestine, it's been pretty obvious to civil society that public funds are available for all sorts of identity groups, but not for pro-Palestine activity. And I witnessed this personally because I was involved 2 or 3 years ago in a startup creating a legal clinic for Muslim Canadians. And we were pushing against an open door at every turn. At every level, political actors and donors were waiting for an opportunity to put money and support into a legal clinic that would serve the needs of this growing demographic, because there are public commitments to diversity and so on. But try doing that as a legal center for Palestine, and you encounter a completely different response, and it's been quite obvious and startling to me. Not shocking and not surprising, because I expected it. How a society wishes to be perceived as progressive and combating discrimination such that it throws the door open to Muslims, yet has very clear boundaries on how far that is willing to go when it comes to Palestinians. And of course, anti-Palestinian racism and Islamophobia are not the same phenomenon, but they are closely related. And I think we need to see more of the kind of thinking and writing that's been happening, analyzing those things, describing how they manifest and how they can be countered with sensible strategies.
Thank you, Faisal. And this question of funding, I think, is really important. But this will need a whole session to discuss, whether it's public funding or funding of universities and organizations and so on, and the weaponization of funding to repress Palestine activism. We have 5 minutes left, so I'll throw in a couple more questions before I move to Layla, and then we can go backwards. There's a question specifically addressed to you, Layla. This question says, how can we explain the very high levels of repression of pro-Palestine voices in Germany and Austria specifically? How is it different from what you've observed in other European countries? And I'll add 2 questions to that. One from me, which is an issue that Layla mentioned, and that's of incitement. So incitement, anti-Palestinian racism have been prevalent in the news media by political figures in the U.S. For example, members of Congress are, clearly making genocidal statements. Are there any legal or otherwise methods to counter those? And there are clearly, there's racism, there's incitement to violence by public figures and political figures. And the last question about the Trump presidency. How would a potential victory for Trump in the US elections impact the repression of Palestine activism in the US? And would that also impact other contexts? Because we've seen a ripple effect in a way, the Trump phenomenon reflected in other parts of the world. So we'll start with Layla, and then we'll move backwards with a couple of minutes. Layla, you'll have some extra time as well because you're answering more questions. Go ahead, Layla.
Yes, I'll actually not take too much of the extra time because it is quite a big topic to open. I don't want to open the Pandora's box on this question. But yes, with the Germany and Austria, it's of course why the repression there it is more than elsewhere is due to their history in relation to the Holocaust, but also due to their fact that they have not learned from history either. So there's a lot that at the governmental and institutional level against anti-Semitism, but it is used actually as a scapegoat to censor other anti-racist movements or speech, but also more than anything, it is very important to know that Germany and Austria do not see anti-Semitism as a form of racism, or they see it as one form of racism, but they really do not look or have any anti-discrimination motivations for other forms of racism. So by emphasizing how much the governments, the German and Austrian governments are doing against anti-Semitism, they try to seem very progressive in terms of being anti-racists, but states can't be anti-racist. That's what people are. People can be anti-racist, not states. But yes, because of this current constant emphasis on what these two countries are doing against anti-Semitism, all other forms of racism and discriminations get thrown under the bus and are actually downplayed, if not even straight out denied. So that's just a very short way of answering it, but there's of course a lot more that can be said about why Austria and Germany are different. But I do want to mention that they're not much more repressive than the UK, the United Kingdom, for example. What is different is that in Germany and in Austria, well, actually just in Germany, due to this constant highlighting of their fight against anti-Semitism, they can openly have all of this repression and violence against the Palestinian communities and people speaking out for Palestine because they have this kind of cover and justification for it. Whereas in the United Kingdom, they're a bit more careful with what is public. This is why, for example, disciplinary investigations are very private, yet they have the same effect as the public smear campaigns and police attacks in Germany have. But yeah, this is all I'm going to say about this topic right now because we are running out of time. Okay. But I will come back to the last one, which was about what we can do in terms of countering the anti-Palestinian racism in the media, etc. I mean, of course, it's a very difficult fight to have against the mainstream media and also the statements by politicians. But it is, I think, very important for us to keep speaking out, but also to speak to our own communities and families and encourage them to speak out against it more and more than anything, to also not let it slide, to have public outrage about it, to try to, for example, this is something that is done a lot in Germany, to answer the newspapers because the readers can send in answers, basically exposing the misleading facts and narratives that they're using. But of course, it is very difficult. However, it is something that we need to keep up, because if we don't, that will be the dominant narrative.
Thank you, Layla. We are out of time, but I want to give Faisal and Maria maybe a few seconds to give concluding remarks and answer any of the questions that you feel still needs to be answered. Faisal, do you want to go next?
I guess I'll just say in 2015, our current prime minister was elected and brought the most diverse representative caucus to parliament that we'd ever seen amongst elected representatives, and claimed that he was going to be doing things differently to represent the population. When UNRWA's funding was cut, the minister in charge was a man named Ahmed Hussein, who's a Somali refugee, came to Canada as a Somali refugee, and rose to prominence. He's a lawyer, and he was elected, and he's now a cabinet member. When he issued that cancellation, he received such negative blowback from average Canadians who saw him as a disgrace, even from members of his own family, who published an open letter essentially disowning him as a disgrace to his community and to his people and to his principles. And so I think there's a whole separate kind of interesting dynamic about diversity in politics and constituents holding their diverse representatives to account. And I think this Gaza war has really pressed that issue, and it's going to be a test for Canadian multiculturalism. And that's a kind of a unique feature we have in Canada, being overtly committed to multiculturalism, but it has only been superficially achieved so far. And so we have, I think Palestine is going to become a litmus test for that experiment.
Thank you, Faisal. Maria, you have the last word.
So just, one thing about Trump, obviously, is his unpredictability, so whatever happens in agencies of the executive, that will be greatly impacted by who's president. The courts are always greatly impacted by who's president. I mean, just a reminder that he imposed sanctions on the ICC prosecutor and another ICC official after they found jurisdiction over the situation of Palestine and around the time that they were considering U.S. official accountability for crimes in Afghanistan. So the international law, rule of law order would be greatly impacted. A lot of it depends on what happens with Congress. They've introduced various laws over the years. They haven't passed at the federal level, but there would presumably be more attempts to criminalize or dismantle support for Palestinians. But it's also the upside down world. There was a campaign speech for Trump where the crowd was, chanting Genocide Joe, and Trump said they're not wrong. So who knows? But regardless of who's the president, obviously it's critical for people to keep speaking out and reaching out to their representatives. And the more political opinion shifts in this country, the more responsive political leaders will be. And that's what it's going to take.
Thank you, Maria. And we have reached the end of our time for the discussion today. On behalf of Kharroub Paris and myself, I would like to thank the speakers for their time and their excellent analyses and contributions. I would also like to thank our audience for tuning in. Please remember to check the next 2 sessions of this conference taking place next Monday and the Monday after. Thank you again for joining us, and take care.